Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking all about lease terminations. Let's get started. So today we're going to cover 6 things you need to consider about lease termination. Well, there's one thing true about every single lease, it's that it comes to an end, but not all leases end automatically. In fact, a majority of residential leases in the state of Texas have an automatic lease renewal provision, or they will lapse into a month-to-month tenancy by operation of the parties. If a lease has a set date of termination, but the parties simply continue with the agreement by virtue of the tenant not moving and the landlord continuing to accept rent, then that lease has not terminated on the date stated in the lease and would have to be terminated in some other way. Your next consideration is where. Where do you look for information regarding termination of a residential lease? Well, naturally, the first place you're going to look is in the lease itself. What is the date of termination? Is there an automatic renewal? What does your lease term say about renewal and about the duties and obligations of the landlord and tenant when it comes to terminating? Generally speaking, termination happens with a written document. If you have a written lease, or even if you have an oral agreement, a writing giving at least 30 days, it could be more, and your lease might require more. But the Texas Property Code further informs us that at the very least you need to give 30 days notice to a tenant if you mean to terminate a residential lease. Now the same is true of a tenant notifying a landlord. So simply because your lease has elapsed into a month-to-month doesn't mean that all the rules go by the wayside, whether those rules are found in your lease or in the Texas Property Code. By default, the code guarantees both parties, landlord and tenant, at least 30 days of notice. Next is the how. How do I deliver notice to vacate to my tenant? Can I simply telepathically signal my tenant that I want this lease to end? No. But it must be in some written form. What forms are acceptable? Well, one place to look would be in the notice provision of your lease. Many leases explicitly say how notices are to be delivered, particularly when they're required in written form. And so your lease might allow notice by fax, notice by email, notice by text, notice only by US mail. It may allow all of them. But if you don't know, you really should look to make sure that you are using an approved method of written notice for your tenant. If your lease is silent, then the easiest way for you to properly deliver written notice to your tenant regarding termination of the lease is to deliver it either in person directly to them by placing it in their hand, or by sending it through US mail. We recommend all notices that you send regarding your lease be sent by regular and certified mail. Could you send your notice through UPS or FedEx? Could you simply post the notice on the outside of the door? That's where things get a little more complicated. You know, a courier service like UPS and FedEx has some form of tracking where you can demonstrate to a court, for example, in the future, if you had to prove that you actually delivered the notice. But simply taping it to the outside of the door is a harder thing to prove. It's definitely harder to prove that the tenant actually got the notice. So generally speaking, we don't recommend simply taping it to the outside of the door. Sometimes, and certainly the Texas Property Code, for purposes of a notice to vacate, will allow you to tape the notice to the inside of the main entry door. If that's your only option for some reason, then certainly you can try that. But again, our recommended #1 method of service of a written notice is by US mail, regular and certified. So same notice, 2 different envelopes, one delivered by regular mail, one by certified US mail. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Next is your who. And as I mentioned before, state law allows either party, and your lease probably does the same, the landlord or the tenant, once your lease has lapsed into a month-to-month tenancy, or if you are approaching the end of your lease, either party can submit notice to the other that they no longer want to continue this agreement. Now again, people sometimes get confused and say, well, at any time I can submit notice of termination to my tenant, or the tenant might think, well, at any time I can submit notice of termination to the landlord. But that's not true. We'll talk more about that later. While it is true that either party can terminate, again, this is once you've reached the point of termination and you're simply letting the other party know, I no longer intend to continue this agreement, or you're already in a month-to-month agreement that only exists in 30-day time periods, that I'm giving you adequate written notice that the lease is terminating. Again, it could be the tenant, it could be the landlord, but either way, as long as the number of days is sufficient and as long as it's done in writing, either side can terminate. Now, this is a pretty fundamental question, and not everybody gets this right, but what is a notice of termination? It is a written declaration that the lease term has ended. It can acknowledge that a lease was signed on an original date X, but that by date Y, it will come to an end. Now, it may be that all you're doing is re-establishing or readdressing the terms that are already in your lease. For example, your lease may say this lease begins on January 1st and ends on December 31st, and your notice of termination simply reiterates that point. And you let your landlord know in writing, absolutely, I'm sending you this written notice letting you know that this lease will end on December 31st of this year, and afterwards it is done. There will be no lease, there will be no tenancy. And again, whether it's the tenant or the landlord, as long as notice is delivered and complied with, there's no beef, there's no problem. The only thing that was anticipated was the original term of the lease. If the matter has lapsed into a month-to-month, you might say, for example, we are in the middle of month X, but next month at the end of it, I wish to terminate this lease. Generally speaking, that is an adequate notice. Now, your lease might require more than 30 days. Sometimes it's 45, sometimes it's 60. Make sure you refer to your lease. In order to have an effective notice of termination in writing, you should address the basic points of your lease, who the parties are, what the original lease term was, and when the date of termination is. When will your notice be effective? And make sure that you've delivered with an adequate amount of time. To understand the amount of time, by default, the Texas Property Code requires no fewer than 30 days, but your lease might require more. Make sure you refer to your lease just in case. So when can I give notice of termination? If the lease requires 30 days or 45 days or 60 days advance notice, at what point is it okay for me to give notice? At what point is it appropriate? So some people use this and literally believe that you have to wait until 30 days out before you can give a notice. So for example, in that same scenario where the lease begins January 1st and ends December 31st, sometimes people are convinced that you have to wait until there are only 30 days left before you give that notice. But that's not precisely what the term requires. The term requires at least 30 days. So you could give 35, you could give 300 days notice, and there's nothing improper about that. What would be improper would be being 300 days out and believing that 30 days is enough to terminate the lease. That's not the way the rule works. You need to give at least 30 days notice perhaps, but the effective date would not be until the lease has essentially terminated. Once you've lapsed into a month-to-month lease agreement, then naturally every 30 days the lease can be terminated as long as you give adequate written notice. But to say that 300 days is too much notice just isn't true. You can give a notice of termination well in advance of the 30 days, and it is still effective so long as you adhere to that notice. So for example, if 100 days prior to the end of your lease, you give your 30-day written notice of termination, but say it is not effective until, in this case, December 31st, and then you give the year. Now, again, there's nothing wrong with giving that notice 100 days in advance because you've given at least 30 days. Where it would be wrong is if, in your thinking, you thought you had to do it within 30 days of the date of termination. That is an incorrect reading of the notice requirement. So it's not 30 days or fewer, it's 30 days or more of advance notice before the end. And again, just because 30 days notice is required does not mean that at any time during the term you can terminate with 30 days notice. Instead, what it means is that the effective date is good no sooner than the last date of the lease. In a 1-year term, that's day 365. In a month-to-month term, that's any 30th day, month-to-month as you proceed. If you have a lease that is nearing the end or has lapsed into a month-to-month tenancy, it's important for you to know what you can do to get out of that lease. Or it's also important to know that at any time the other party can get out of this lease. And so you'll need to plan appropriately. This might mean having to talk with your tenant to establish a new year term. It might mean that you send this notice to terminate to the tenant because you have different plans with your property. But unless you are adhering to the basic tenets of what we discussed today, you may not have an effective termination of your lease. Stick to the how, when, where, why, what, and who of today's video, and I believe you'll do just fine. For more video content, take a look at what YouTube seems to think you will enjoy. And until next time, happy leasing.